Treason is not the reason for the season. Episode 20, Heller, Part 1. 2 Centuries of Precedent prior to Heller 2008. Or, the Founding Fathers weren't actual idiots. To understand the insanity that is the 2008 Heller ruling, you first need to understand the Founders' design, that was in operation from 1792 until 2008. This video attempts to explain the Founders' design. And once you understand the Founders' design, the next videos will explain how Heller broke it all. The design is apparent in the documents upon which the Founders designed our nation, and the legal precedents that came in the 2 centuries that followed it. 1776. Declaration of Independence declares the states are independent from the King of England. It declares a right to life, liberty, and happiness, but no right to armed self-defense. See video number 2, Declaration of Independence. 1776, and soon thereafter, with independence declared, 12 states threw out their charters and wrote state constitutions. 5 state constitutions mentioned no right to bear arms at all. 5 state constitutions mentioned arms tied to militia service only. 2 states' constitutions mentioned a right to bear arms for militia service and a right to armed self-defense. 1777. 1 year later, Articles of Confederation were written. It mandated that every state shall always keep up a well-regulated and disciplined militia, sufficiently armed and accoutred, and shall provide and constantly have ready for use, in public stores, a due number of filed pieces and tents, and a proper quantity of arms, ammunition, and camp equipage. It mandated that all states keep a militia, but this was not tied to any personal or individual right to bear arms. Instead, it mandated that states would have to provide a proper quantity of arms and ammunition for the militia, kept in public stores, i.e. in state-controlled armories. There was no individual right to bear arms in the Articles of Confederation, and no personal right to armed self-defense. See video number 3, Articles of Confederation. George Washington, in letter to Hamilton, 1783. It may be laid down as a primary position, and the basis of our system, that every citizen who enjoys the protection of a free government, owes not only a proportion of his property, but even his personal services to the defense of it, and consequently that the citizens of America, with a few legal and official exceptions, from 18 to 50 years of age should be born on the militia rolls, provided with uniform arms, and so far accustomed to the use of them, that the total strength of the country might be called forth at a short notice on any very interesting emergency. Washington is spelling out a national draft for militia service. He is not describing a personal right to armed self-defense. In fact, Washington's letter makes clear that Washington wasn't asking for every man be personally armed, but rather every man be provided arms by the state. Arms that might even be stored in a state-controlled armory, as spelled out in the Articles of Confederation. Washington's priority here isn't a personal right to armed self-defense, but rather federal access to state militias. From the U.S. Constitution, 1787. Congress shall have power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia. The federal government has fundamental constitutional authority to command, organize, regulate, and discipline state militias. Under the Articles of Confederation, the Founders found themselves unable to stop Shays' rebellion. Shays and 4,000 men ran amok for nearly 10 months before the governor of Massachusetts put together a militia and ended the rebellion. These clauses show the Founders wanted direct command and control of state militias so they could protect the nation. See video number 5, Constitution and Bill of Rights. 1789, Bill of Rights goes through drafting process. Excerpt from Draft Bill of Rights by James Madison submitted to Congress, July 17, 89. The right of the people to keep and bear arms shall not be infringed, a well-armed and well-regulated militia being the best security of a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. The Conscientious Objector Clause makes clear this right to bear arms is about militia service. Approved by the House, August 17, 1889. A well-regulated militia, composed of the body of the people, being the best security of a free state, the right of the people to keep and bear arms, shall not be infringed, but no one religiously scrupulous of bearing arms, shall be compelled to render military service in person. Again, the Conscientious Objector Clause points to this being about militia service. Ratified December 17, 91. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. The legal text of the Second Amendment ties the right to bear arms to militia service. As the text was being worked out, the different state constitutions and their various right to bear arms clauses, or no clause at all, were all looked at, and this was the wording chosen. The two states with clauses that explicitly enumerated a right to armed self-defense was known, but that wording was rejected. The version chosen was compatible with all state constitutions that existed at the time. States with no right to bear arms and had existing gun control laws, could continue to regulate arms outside militia service, laws that regulated guns and powder, open and concealed carry, and so on, could be kept in place. The two states with a right to armed self-defense could keep the right to armed self-defense within their state. See video number 5, Constitution and Bill of Rights. Militia Act 1792. Required every able-bodied man register for militia service. Required militia members to possess 1 musket, 24 shot, powder, bayonet, 2 spare flints, powder horn, knapsack, and so on. States that members of the militia shall receive the same pay and allowances as the troops of the United States. States that members of the militia shall be subject to the same rules and articles of war. States that every officer, non-commissioned officer, or private of the militia, who shall fail to obey the orders of the President of the United States, shall be subject to court-martial. 1 year after the Bill of Rights is ratified, Congress passed the Militia Act of 1792, which placed massive regulations on militias, to the point that they were subject to the same laws, including court-martial, as the full-time army. See video number 6, Militia Act of 1792 and the Whiskey Rebellion. The Constitution's militia clauses gave Congress powers for organizing, arming, disciplining, and governing the militia. The Second Amendment mandated that all states must allow arms for militia service. The Militia Act of 1792 defined 1 musket, 24 shot, and a quarter-pound of powder as the specific list of arms that all states must allow. All other arms were left to the states to regulate as they chose. This is how the Founders designed our Constitution and Bill of Rights. It's all there, in black and white, plain as day. This was, for the most part, the position of the courts for roughly 2 centuries. The federal right to bear arms was tied to militia service. States could regulate arms as long as those regulations did not prevent a state militia from being formed. Militia members were not intended to have every imaginable weapon in their possession, nor were they intended to have ammunition enough to fight an entire war. The Militia Act of 1792 mandated that militia members possess a single musket, 24 shot, a quarter-pound of powder, and no more. The full-time military maintained heavy weapons such as artillery, forts, and warships, and the full-time army would deploy these weapons, with the militia armed with muskets acting as a supplement to their operation. Militia members would support the full-time army and would be resupplied with ammunition by the full-time army in times of war. All other weapons besides this single musket and 24 shot, were left to the states to regulate. And in times of peace, the states could put some regulations on how the militia arms were stored and carried. At the federal level, the Constitution contains multiple clauses about militias. 1 to give Congress the power for organizing, arming, disciplining, and governing the militia. And 1 to render the militia subservient to the President along with the rest of the military. The Second Amendment states that the right to bear arms is tied to militia service. and Congress passed the Militia Act of 1792, which instituted a militia draft, mandated militia members must possess a musket, 24-shot, and powder, and subjugated the militia to the same laws as the military. All this text in all these different federal documents about militias. And nowhere to be seen is any reference whatsoever to armed self-defense. The Constitution doesn't give Congress the power to define what is armed self-defense and what is vigilante behavior and what is homicide. Nowhere in the entire Bill of Rights is any mention of a right to armed self-defense. And the Congress of 1792 never passed any sweeping legislation to define what was expected of citizens as they exercised their right to armed self-defense, no laws to draw any lines between armed self-defense and vigilante behavior and homicide. No text of any kind whatsoever anywhere at the federal level. At the federal level, this was the interpretation of the Second Amendment for the next 2+ centuries. It is not overturned until the idiocy that is the 2008 Heller ruling. We'll get to that idiocy in a bit. There are two specific cases to review before discussing the idiocy that is Heller, Nunn v. Georgia, and U.S. v. Cruikshank. Watch video number 19, Nunn v. Georgia, 1846 for more information. In Nunn, a pro-slavery judge in Georgia very much wanted to give white slave owners a personal right to carry arms whenever they wanted, to protect against slave revolts and to fight the North. The Civil War would start just 15 years later. The judge's problem was that the Georgia state constitution at the time had no wording whatsoever that was even close to allowing a personal right to bear arms. Instead, it said, "Every county in this state that has, or hereafter may have, 250 men, and upwards, liable to bear arms, shall be formed into a battalion." That was the only clause in the Georgia Constitution that mentioned arms at all. And so, the judge looked at 3 other state constitutions that were not Georgia's constitution, that did have a personal right to armed self-defense, and with no basis in reality, decided that very specific, explicitly worded right in a state constitution, that every citizen has a right to bear arms in defense of himself and the state, was actually what the founders intended with the Second Amendment, even though the Second Amendment very specifically did not contain those words. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. For the first half-century of U.S. history, state gun control laws were allowed based on the understanding that the Second Amendment protected a right to bear arms for militia service only. States could regulate arms as long as it didn't get in the way of militia service. And the Militia Act of 1792 defined the arms expected for militia service to be exactly 1 musket, 24-shot, and a quarter-pound of powder. The Nunn ruling ignored half a century of precedent and was the first ruling where a gun control law was thrown out based on the Second Amendment, and the Nunn ruling is absolute garbage. 1874, U.S. v. Cruikshank. Cruikshank was the first case to come before the Supreme Court that involved a possible violation of the Second Amendment. In this case, the Supreme Court unanimously ruled. The Second Amendment declares that it shall not be infringed, but this, as has been seen, means no more than that it shall not be infringed by Congress. This is one of the amendments that has no other effect than to restrict the powers of the national government. The Cruikshank ruling made explicit what had been understood for nearly a century, namely that the Second Amendment only protects a right to bear arms for militia service, that it does not protect any other right regarding arms, it does not protect any personal right to armed self-defense. Individuals must look to their states to create and secure whatever personal right to bear arms their state will support, if any. This interpretation was how the nation operated for over 2 centuries. It is not overturned until the idiocy that is the 2008 Heller ruling. The push to interpret the Second Amendment as a federal mandate upon the states for a complete deregulation of all guns did not become a significant movement until the 1960s. Why? Because the 1960s saw the passage of the Civil Rights Act and the Voting Rights Act. The first century under the Constitution, slavery was allowed at the state level. The next century under the Constitution, Jim Crow segregation under separate but equal was allowed at the state level. During this period, white supremacists were able to use state governments to enforce the subjugation of blacks and other minorities. And so, white supremacists went along with the government because it gave them what they wanted. With the Civil Rights Act and Voting Rights Act, white supremacists found the government, at least at the federal level, had become a major obstacle for them to subjugate blacks and other minorities. And so, starting in the 1960s, the United States saw the birth of a major white supremacist anti-government movement. The Turner Diaries, published in 1978, described as the Bible of the racist right, tells the story of white supremacists overthrowing the federal government, taking over the entire world, and committing genocide against minorities. The Posse Comitatus organization, a white supremacist anti-government group, was founded in the 1960s in direct response to the Civil Rights Act and Voting Rights Act. They would play a role in the birth of the anti-government militia movement in the 1990s. Timothy McVeigh was a white supremacist who blew up the federal building in Oklahoma City, killing 168 people. When he was captured, he had pages from the Turner Diaries with him. In 2002, FBI Assistant Director Dale Watson testified before the Senate, saying that since the 1990s, right-wing extremism had become the most dangerous domestic terrorist threat to the country. In 2021, FBI Director Christopher A. Wray testified before the Senate saying that domestic right-wing terrorism incidents had doubled in a year, that the number of investigations into white supremacists has tripled, and that domestic terrorism has been metastasizing around the country for a long time now. This shift to deregulate guns can be seen even in organizations like the National Rifle Association. The NRA used to support common-sense gun control laws. The NRA supported the National Firearms Act of 1934, which regulated machine guns, explosives, suppressors, and other weapons. The NRA supported the Mulford Act of 1967, which enacted some strict gun control laws, and prohibited open carry. The NRA supported the Gun Control Act of 1968, which was passed in response to the assassinations of JFK, prohibiting felons and mentally ill from possessing firearms. For decades, the NRA supported reasonable gun control laws. At least until the 1960s. But by 1986, the NRA was pushing for the Firearms Owners Protection Act, FOPA, which undid many parts of the Gun Control Act and prohibited the federal government from registering firearms, a major tool in keeping guns out of the hands of criminals. The 2008 Heller decision is just another part of this push by white supremacists and anti-government jackalopes to deregulate guns so they can hoard guns to terrorize blacks and so they can hoard guns to overthrow the federal government. Watch video number 23, Tale of Two Democracies, or It's the Racism, Stupid, for more details. In 1792, the United States operated under the Founders' design. The Constitution gave Congress the power to regulate militias and made militias subservient to the President. The Second Amendment protected a right to bear arms for militia service only. And the Militia Act of 1792 mandated that the arms expected for militia service consisted of 1 musket, 24 shot, and a quarter pound of powder. All other arms were left to the states to regulate. And in times of peace, states could even put some regulations on how militia arms were stored and carried. The Second Amendment protected no personal right to armed self-defense. This was left to the states to decide. And in 1792, only 2 state constitutions had a personal right to armed self-defense. 5 state constitutions had a right to bear arms for militia service only. And 5 state constitutions had no right to bear arms whatsoever. Those last 5 states would be mandated by the Second Amendment to allow a right to bear arms for militia service only. But all personal rights to bear arms were up to the states to decide. This design, more or less, was in play for over 2 centuries. The Heller ruling of 2008 completely destroyed this design. And the Heller ruling is a complete pile of garbage. Treason is not the reason for the Second Amendment. Treason is not the reason for the season.